it's a stark departure from the days of, Clinton era safe, legal, and rare, right? But the problem with that has always been that if you say safe, legal, and rare, why should it be rare? Are you admitting that there's something bad about abortion? And if there's something bad about abortion, shouldn't we be restricting it or regulating it or prohibiting it? And so I think that the pro-abortion movement is unwilling to admit that there can be anything bad with abortion, because that would justify legislative and legal attempts to prohibit it or limit it. And so I think that this move toward abortion as a positive good is a reflection of that.
Join the best in the movement. It's Conservative Conversations with ISI, educating for liberty since 1953. Welcome back. You're listening to Conservative Conversations with Marlo and Nate.
Today, Josh Craddock is an affiliated scholar with the James Wilson Institute for Natural Rights and the American Founding, is joining us to discuss a particular legal interest of his, which is the topic of abortion. A few weeks ago, a draft of the Dobbs v. Women's Health majority opinion was leaked, and pro-life Americans are eager for a decision in the case that would overturn Roe v. Wade. Thanks for joining us, Josh.
Glad to be here.
So before we get started with our interview, I'd like to thank you for listening to Conservative Conversations. This podcast is a production of the Intercollegiate Studies Institute. Our mission at ISI is to educate for liberty. If you would like to help us in pursuing that mission, please rate and review this podcast on Apple Podcasts to help us reach more listeners like yourself. So, Josh, can you bring our listeners up to speed on this leaked majority opinion? I'm sure everyone has probably heard of it in the news over the past few weeks, but what exactly hangs in the balance as we await the court's determination?
Yeah, so the Dobbs decision is the most important decision on the question of abortion for more than about 30 years. Basically, there are two cases that the Dobbs case is calling into question. So the 1973 decision, Roe v. Wade, that many of us are familiar with, which was a decision that required states to allow abortion practically through all 9 months of pregnancy by discovering a right to abortion within the 14th Amendment. Specifically in that case, situated within the right to privacy. Fast forward to 1992, there was the Casey versus Planned Parenthood decision, which reaffirmed the central holding of Roe and situated the right to an abortion, again, through all 9 months of pregnancy, in the liberty that's protected by the Due Process Clause of the 14th Amendment. So at issue now in the Dobbs case is whether those prior decisions are still legitimate. And so the Dobbs case comes up from a Mississippi law that prohibits most abortions after 15 weeks. And so the question presented was whether those state regulations on abortions before viability are constitutional. And so the Supreme Court is currently grappling with the question of whether there is this constitutional right to abortion and whether state laws like Mississippi's that prohibit abortion are allowed. And so the question is really about what the meaning of the Constitution is, what the meaning of the 14th Amendment and the liberty interest that's protected by the 14th Amendment means. And it's a really exciting time because the draft opinion, if that's any indication of what the final opinion will look like, which we're hopeful that it is, it basically reflects that there is no long-standing historical liberty that protected abortion at common law or in the history of it's not firmly rooted in our nation's history or traditions. And so that would overturn Roe and Casey and essentially find that there is no constitutional right to an abortion.
Josh, can you talk a little bit about the potential decision in the context of this broader discussion of the legitimacy of the court? Because I think one thing that you hear thrown around by both sides, both proponents of Roe v. Wade and opponents of Roe, is this discussion of the legitimacy of the court. And that's definitely something that you hear cited by some justices, most prominently John Roberts, in terms of how they think about these decisions, is how it actually affects the way that Americans see the court. It seems like both sides are making the threat that if the court rules against their preferred outcome, it will harm the legitimacy of the court. And I think maybe to an extent they're both right, because Americans on either side of the aisle will see the court's legitimacy as seriously harmed if they rule the wrong way, in their opinion. But what do you make of those sort of discussions? What do you make of the sort of broader discussion of the legitimacy of the court, particularly in the context of this potential landmark ruling?
Well, it's certainly true that the Supreme Court and the justices of the Supreme Court take seriously the institutional respect for the court, and that it's just deciding law and not just legislating from the bench. I think a lot of the criticisms about institutional legitimacy are sometimes misplaced in the sense that, for example, in the Casey decision, the court was flooded with arguments and it actually made its way into the opinion that if Roe was overturned, it would undermine the legitimacy of the court because it would be admitting that the court got it wrong. But the court has gotten it wrong before, right? We know the we've had these lists of cases that are the kind of Hall of Fame bad cases from the Supreme Court, many of which have been overturned. So Dred Scott versus Sanford, right? The Dred Scott decision that decided that Black Americans were not citizens, that harmed the legitimacy of the court, and it was actually good when that was overturned unfortunately by amendment rather than litigation. But Plessy versus Ferguson. Another example, the separate but equal doctrine that was overturned in Brown versus Board of Education. It was good for the court's legitimacy to overturn that decision. And so I think some of the legitimacy arguments, especially coming from people like Senator Schumer, who stood in front of the Supreme Court and said, if you do this, you're going to reap the whirlwind, and basically threatening the Supreme Court with expanding the number of seats, number of justices who sit on the court if the court doesn't rule the way that they want. I think that actually is what undermines the legitimacy of the court, not a careful reconsideration of prior decisions, especially when those careful reconsiderations are based on the actual law and the Constitution rather than simple policymaking. So some of the criticisms that I've heard of Justice Alito's draft opinion, which again, to emphasize, is not the final opinion of the court, hasn't been released, is kind of an unprecedented thing for this draft opinion to be leaked. But some of the criticisms I've heard of that draft opinion have been that, well, this is just, playing politics and reaching a goal that conservatives like. Or even Justice Sotomayor from the bench during oral argument in this Dobbs case, saying that it would be a stench for the Supreme Court to overturn Roe after it's been on, this precedent for about 50 years now. The stench is actually the fact that the Roe court itself established this constitutional right to an abortion without any basis in the Constitution itself, its text, its history, our traditions under the common law. It invented this right out of thin air. And that's actually the problem, is that was the judicial policymaking and legislation from the bench that creates a stench and creates the perception that the court is just acting politics. So the left's argument that the court is going to lose institutional legitimacy is actually just they're the ones who are creating this self-fulfilling prophecy of undermining the court's legitimacy by saying that this draft decision or the Dobbs decision, once it's actually released, is just a matter of politics rather than law.
The follow-up question in that vein is obviously the unprecedented nature of the leak itself, right? And I think when we're talking about the legitimacy of the court, there's been some, I think, legitimate sort of discussion of how this unprecedented decision does radically change the way that justices think of their relationship to one another and think of their job. I'm curious, in general, what you make of the nature of the leak. If you have any sort of tinfoil hat conspiracy theories about who leaked it, there's obviously been some discussion about that. But in general, I mean, this was sort of an unprecedented move by an anonymous clerk. Is that right?
Yeah. Information has leaked from the court before, but we've never seen a draft opinion like this, complete with footnotes and ready to be circulated among the justices. We've never seen anything like that leaked before. And I think it really does undermine the working of the court. It harms the court's legitimacy. I think the leaker probably recognized that, and by leaking it, undermine the court's legitimacy in doing so. I've clerked for a federal judge, and I think that the confidence that you have between the judge and the clerk is very important. And so if indeed it was a clerk who leaked this, I think that breach of confidence is remarkable and really disconcerting. I think it's going to hurt the justices' ability to confer with not only their clerks, but with the other justices and have that level of trust to be able to have these conversations on really charged issues. So I think it's very unprecedented. I also think my immediate suspicion was that, it's more of a left-leaning clerk who leaked this. And I think that that's still the best guess that we have so far based on the people who are celebrating the leak. I mean, you see Demand Justice, Slate, legal commentator, other people celebrating this leak. Those are all coming from the left who are celebrating the leak. And so I think that that's an indication of who might have had incentives to leak this. But, at this point, we don't know for sure, and it would be pure speculation to guess.
Josh, you've written extensively about the Originalist case for prenatal personhood, and it seems like you were kind of hinting previously at that. Could you explain what that means and what the case is there, and perhaps how historically that's stood up, and perhaps how Roe itself was maybe an aberration from that?
Yeah, absolutely. So one of the things that's interesting about the Roe decision is Justice Blackmun actually admitted in his decision that if the case for that if personhood of the fetus was established, then the case for abortion would collapse. For the fetus's right to life would then be guaranteed by the 14th Amendment. And what he's referring to is the 14th Amendment's guarantees of due process and equal protection, which guarantee to, quote, any person the due process of law and the equal protection of the laws. And so the structure of the argument, the constitutional case for life, is actually pretty simple, that 14th Amendment's use of the word person extends to all members of the human species. It used extremely broad language of any, and then person having a very historical settled meaning at the time the amendment was adopted in 1868 that included all human beings, and in fact specifically included unborn human beings. So the 14th Amendment then protects the preborn. So if the preborn are members, biological members of the human species, then all you really have to show is that the term person, in that original public meaning at the time that the 14th Amendment was adopted, applied to all members of the human species. And so I've written pretty extensively on this for the Harvard Journal of Law and Public Policy and elsewhere, drawing on different strands of evidence to support that conclusion about the original public meaning of the amendment in 1868. So first, you could look at dictionaries of common and legal usage at the time of the 14th Amendment's adoption, which define the terms person and human being interchangeably. So the original public meaning of the term person, in general parlance and also in legal usage, included every member of the human species. Some evidence of this can be found, going back in the common law, the meaning of person, and going back to Blackstone's commentaries. The first book of his treatise, The Commentaries on the Laws of England, which was extremely influential in the American colonies and the states right after the American founding. The very first book of that treatise is titled Of the Rights of Persons. And in the first chapter of that book, he actually opens the discussion with a discussion of the rights of unborn children to personal security and life. So it's like at the very foundation of the rights of persons. So that's the first kind of line of evidence. Secondly, those centuries of common law precedent and state practice leading up to the 14th Amendment's adoption indicate that the unborn were considered legal persons. So we have all that common law context that I just mentioned, but then there was actually this wave of state legislation between 1820 and approximately 1880, where states were passing laws to codify that common law prohibition on abortion in state statutes. And those statutes were often classified within the category of offenses against the person. And oftentimes the statute would refer to the unborn child as a person, an infant, or a child. So there's all this historical evidence that right up to the time leading up to 1868, when the amendment was adopted, the states widely considered the unborn to be legal persons. And then finally, the third line of evidence that I draw on is that the authors of the 14th Amendment themselves expected it to protect every human being, especially the weakest and most marginalized. And so that original expected application, although it doesn't, completely exclude or define the extent of the amendment, that it's indicative of the original public meaning. And it shows that informed citizens believe that the text of the 14th Amendment applied to every human being without exception.
Just to dive into the historical context a little bit more, how much was abortion a topic of political discussion at the time that the 14th Amendment was ratified? Because if you look at the history of abortion as a political issue, prior to Roe v. Wade, things were much murkier in general. I mean, I've written about this a little bit. The Republican Party was far from the pro-life party. The most radical abortion law in America prior to Roe v. Wade was signed by Nelson Rockefeller, who's a liberal Republican in New York. And a lot of Democrats were pro-life because Catholics were a Democratic constituency. But in general, it was sort of a third or fourth tier issue. It just didn't have the same prominence that it gained after the religious right mobilized post-Roe. I also think just technologically, things were different, obviously, at the time that the 14th Amendment was ratified. So perhaps mass abortion was not quite as feasible. But of course, I'm sure that it did happen. And I'm sure that there were political debates about it. Is there anything that you look at in terms of how lawmakers were discussing the issue in political terms around the time that the 14th Amendment was ratified?
Yeah, so that's a great question. And you're absolutely right that, kind of the mid 1900s, that was certainly the case. I'm from Colorado. Republican Governor John Love was the signer of the first permissive abortion law in Colorado. And I think it was 1967. So that's absolutely true that it didn't have the same partisan divide in the mid 20th century as it does today. But actually, the question of abortion in law goes way back. So some of the earliest cases dealing with abortion back in England go back to the 13th century. So this was an issue. And even in the Hippocratic Oath that doctors swear, actually one of the requirements of the Hippocratic Oath was not only to do no harm, but to give no woman an abortion. So this goes way back in history. But in the American context, kind of the high watermark for abortion discussion in state legislatures was that period between 1820 and 1880. So there was a guy named Horatio Storer who led what was called the Physicians' Crusade against abortion. And so these state legislatures were beginning to codify those common law prohibitions against abortion in their state statutes. And they're still surviving a lot of the legislative history and discussions about that. So for one example, Ohio is a great example. So in April 1867, just 3 months after they had ratified the 14th Amendment, the state of Ohio passed anti-abortion legislation that prohibited abortion at all stages of pregnancy. And it's amazing some of the language in that legislative history where they actually refer to abortion as child murder. There's some very strong language about it. And these legislative initiatives were supported by the American Medical Association and other medical associations around the country, which is kind of hard to believe today now that the American Medical Association is so beholden to the pro-abortion lobby. But back then it was not like that. And it was a physician's crusade against abortion because of the interest in preborn life.
Josh, I'm curious what your thoughts are on the viability argument, especially as technology advances and viability becomes earlier and earlier in gestation. Do you think that that narrative about viability will kind of be challenged by these technological advances? And I'm curious in total, what you're, from a legal perspective, especially, but also perhaps from a one that is more also political, how pro-abortion advocates will need to adapt their arguments for abortion in the wake of these technologies being developed that can support life outside the womb before the end of the third trimester.
Yeah, well, that's a great point. And the viability line has been criticized for a long time based on the exact reasoning that you just explained. Casey, when the Supreme Court decided the Casey decision in 1992, a lot of the response was an observation that this viability standard was in a collision course with itself, because as medical technology develops, earlier and earlier preborn children are able to actually survive outside of the womb, to where now even some children as early as 21 weeks gestation are able to survive outside the womb in some circumstances. And so that viability line keeps getting earlier and earlier. And I think that also shows the viability standard that was invented by the Supreme Court really has no basis in medicine and certainly not the Constitution, which is what they're supposed to be interpreting, right? This viability standard comes out of nowhere in the Constitution. So I think you're exactly right to criticize it. And I think that is part of the reason why the justices in the Dobbs case are unwilling to reformulate abortion constitutional law based on the viability standard and try to say, well, some pre-viability abortion, legislation is constitutional, others isn't. I think they're inclined to get rid of that viability standard altogether just because it doesn't make any sense and it has no legal basis.
But interestingly enough, of course, at least if the draft opinion holds, they're also not willing to go the other way and talk about personhood, at least in terms of the 14th Amendment. And I think that's been frustrating to some conservative legal writers like you and a lot of other folks who want the justices to interpret the 14th Amendment to apply to unborn children. I think that the debate that is occurring within the conservative legal movement along these lines sort of has two different components, because one is just strict sort of constitutional debate about whether or not unborn children are entitled to personhood under the 14th Amendment. But the second one, and cards on the table, I'm pretty sympathetic to your argument on that. But I think the compelling argument, just in terms of jurisprudence, is a prudential one, which is that if the justices go all the way in the other direction, if the justices come out tomorrow and rule that actually not only is Roe v. Wade overturned, but actually abortion is banned nationwide under the 14th Amendment, as satisfying as that would be to pro-lifers, the entire country might burn down. And perhaps being scared of the sort of left's reaction is not actually a viable argument against ruling the correct way constitutionally. That's a compelling argument. But at the same time, I do think there are sort of prudential considerations that have to be considered, because if you are a pro-lifer who also wants the country to not burn down, actually advancing your goals slightly more incrementally to get to a place where America can still exist and abortion can be banned is probably a prudential sort of argument for not going all the way in the other direction. I'm curious what you make of that, if you think that's compelling or not.
Yeah, I think that from what we've seen from the leaked Dobbs opinion, I think that some of the radical elements on the left are willing to try and burn things down regardless of what the decision looks like, as long if it restricts abortion in any way. But I think that to be clear, I think that this 14th Amendment argument that I've advanced, that the unborn child is entitled to the equal protection of the laws, regardless of, in every state in the union. I don't think that the Dobbs opinion undermines that, because what the Dobbs opinion is doing is it's deciding a specific question that was presented to the court, whether state laws regulating and prohibiting pre-viability abortions are constitutional. And to answer that question, the court doesn't need to reach this 14th Amendment argument. And in fact, the 14th Amendment argument wasn't presented by the parties. There are some excellent amicus briefs filed. In fact, 20% of the amicus briefs filed in support of the state of Mississippi made the 14th Amendment argument, including one really excellent amicus brief that I recommend by John Finnis and Robert George, making this 14th Amendment argument. But the parties themselves did not raise this argument, and typically the Supreme Court isn't going to address an argument that hasn't been fully briefed or presented by the parties. And so there are already kind of prudential doctrines built in about party presentment, the question presented that limit the Supreme Court or justified the Supreme Court in making this kind of first step toward comprehensive protection for the unborn. And so I have never expected that the Dobbs decision would go all the way to adopt a 14th Amendment argument. I think it's one step toward moving that direction. And I think that some of the reasoning in Dobbs actually lays the groundwork for a future decision that could recognize the unborn as persons under the 14th Amendment. So, for example, if the final Dobbs decision looks anything like the draft opinion by Justice Alito distinguishes other substantive due process cases based on the fact that, those, for example, contraception, sexual autonomy cases, those cases, none of them involve the destruction of another human being. So, and that distinguishes this case from any other substantive due process case that the court has decided. And I think that lays the groundwork for determining what that human being is when we're working out, why is it distinct? So if it's different from those other cases because abortion destroys a human being, then the next natural question is, well, does the Constitution protect such a human being in the womb? And so I think that actually lays the groundwork for future decisions that could recognize unborn personhood under the Constitution.
What do you make, though, of the sort of prudential statecraft argument that getting too far out ahead of public opinion actually could make those victories unsustainable? I mean, in an interesting inverse way, this was Ruth Bader Ginsburg's argument against Roe v. Wade, was that it got too far out ahead of public opinion. So from the pro-choice perspective, it actually harmed the pro-choice cause and created this backlash, which in many ways is probably culminating right now. There could be an argument in the inverse, and I'm thinking, I just did Claremont's Publius Fellowship last summer, so I'm thinking of Jaffa and Lincoln and the discussion of not getting too far out ahead of public opinion and advancing long-term goals. If the Supreme Court in 6 months or 2 years even releases a subsequent opinion that bans abortion nationwide, that actually could create the kind of backlash that would perhaps undo all of the progress that we've made in terms of Roe, and actually the harder, slower process of persuasion and slowly bringing American people along, as unsatisfying as that is, because abortion will continue in blue states for a much longer period of time, is probably the way to notch more concrete victories that last for the pro-life cause than the alternative?
Yeah, I think I have two responses. So I think the first response is it's certainly true that public opinion matters and that judicial decision-making, there's an element of statecraft and prudence that's part of that art of judicial decision-making. As you mentioned, you brought up, the Publius Fellowship and Claremont. I mean, Abraham Lincoln said that our government rests in public opinion and that public sentiment is everything. And so there's a way in which, borrowing from the Federalist Papers, good statesmen refine and enlarge the public view, right? They have an educational role to play. I don't think that's limited to judges either, right? The president and congressmen and women have an obligation and a duty to help refine and enlarge the public view, to help understand that unborn child in the womb is a person and is entitled to legal and constitutional rights. So there's certainly a prudential element there. On the other hand, I think that there is an aspect in which the court and policy shapes public opinion. And so it's not just a one-way street where you have to have public opinion before you make policy or make decisions. The Brown v. Board of Education case is a great example where the simple fact that the court came down against segregated schools, there was a massive backlash to that, right? You recall in the South, massive, standing, the Dixiecrats against segregation. Or in favor of trying to defend segregation. So there was a massive backlash. And yet the court's decision in Brown v. Board was actually a marker of public opinion that helped shape the public view and the understanding of our equality. And so I think that actually, there's a reciprocal element in which the way that the law is a teacher that helps educate the public and change public opinion as well.
On the subject of public opinion, I'm curious what your thoughts are on how abortion became understood as a positive good by its proponents, and just how do you think attitudes toward abortion have shifted over time so that the proponents have adopted that notion of abortion?
Yeah, you see this now in the shout your abortion movement, or people baking cakes celebrating their abortion. I think it's a stark departure from the days of Clinton era safe, legal, and rare, right? But the problem with that has always been that if you say safe, legal, and rare, why should it be rare? Are you admitting that there's something bad about abortion? And if there's something bad about abortion, shouldn't we be restricting it or regulating it or prohibiting it? And so I think that they're just the pro-abortion movement is unwilling to admit that there can be anything bad with abortion, because that would justify legislative and legal attempts to prohibit it or limit it. And so I think that this move toward abortion as a positive good is a reflection of that. And it actually has an echo of, some of the same discussion that we were just having about, the antebellum era and the debate over slavery, right? You saw at the beginning, at the founding of America, slavery was seen as a necessary evil, right? Whether that's true or not, that's the way it was seen. Thomas Jefferson, for example, adopted that view. He personally opposed slavery, but yet owned slaves and believed it was a necessary evil. That developed and changed in the early 1800s to where you have Alexander Stephens saying that slavery is the cornerstone of the Confederacy and a positive good. And so that defense, it's kind of the same thing when they felt that, when the South felt that slavery was threatened as an institution, they couldn't admit that it was a necessary evil anymore, because that would set it on the path toward gradual abolition. And so you had to defend it as a positive good. And it's the same sort of rhetoric that we see today from the left defending abortion in those same terms.
I saw some of these images circulating, comparing American abortion laws to Western Europe's, for example, even the Nordic states. And it seems like American attitudes are just very disconnected from the international and European even approach to abortion. And perhaps in Europe that attitude is still there, that safe, legal, and rare, as awful and as I think abortion should be prohibited, of course. But that it seems like it's uniquely American that this positive good argument has developed. So I'm curious what you think about how our American abortion laws measure up to the rest of the world.
Yeah. Well, you're certainly right. America is an extreme outlier on the question of abortion. There's only, I believe, 7 other countries that allow abortion to the extent that the United States does. And among those are North Korea, Vietnam, and China. Canada is one of the others. And so it really is an extreme outlier when you compare it to other countries in Europe, for example, where abortion is generally prohibited after 12 weeks or so. so it's an extreme outlier there. And I think it is interesting because the same people who are, saying that, women will die if Roe is overturned, they aren't paying attention to those, European countries where abortion is much more restricted than it is here in the United States. And I think they're especially not paying attention to other countries that have comprehensive protection for the unborn and provide excellent maternal health care to women. So, for example, Ireland until 2017 prohibited all abortion, and there they had the number 3, I think it was number 1 or number 3 best maternal mortality rate in the world. So the lowest rate of maternal mortality in the world. In the Americas, for example, Chile since 1989 prohibited all abortions. I think more recently in 2019, they've relaxed that a little bit. But between 1989 and today, Chile has had, I think, the second best maternal mortality rate in the Americas, much lower maternal mortality than the United States, even though they completely prohibit abortion. And in fact, one of the interesting facts about Chile was that the mothers seeking abortion unlawfully actually declined over time because Chile was providing educational and support resources to women so that women weren't seeking abortion at as high rates. So it's completely possible for countries to both comprehensively protect life and provide excellent maternal health care to women. There's no trade-off there.
In terms of the discussion of comprehensively protecting life post-Roe, this is perhaps a more political question than it is a legal question, but there's obviously been a lot of debate in Republican and conservative circles about what a more sort of robust pro-family conservatism would look like. And to be honest, I think that conservatives and Republicans are going to be on the hook a little bit post-Roe. Obviously, the left-wing talking point about how you're not pro-life if you don't, support Medicare for all for something is dishonest, because just because we don't have Medicare for all doesn't rob a child of its personhood or justify murder. But I do think there is something to the basic point that women will continue to seek abortions even if they're banned, unless they're given a viable alternative option. And I think there are a suite of conservative policies and approaches, particularly at the state level, that can give them more robust alternative options. But I'm curious what you make of some of the discussion of, things like child tax credits, in terms of, perhaps sort of beefing up aspects of the welfare state to make it easier on low-income mothers. Are you someone who supports those policies, and what would a sort of pro-family post-Roe Republican agenda look like?
Yeah. Well, I've always thought it's funny when people say, the pro-abortion lobby says like, well, you don't care about children after they're born because you don't provide, you don't support these government sponsored resources. But of course, I would challenge any of them to go to a Planned Parenthood and see if you can get baby formula, a crib, clothes, diapers, support for your rent, car payments, and yet those are exactly the same sort of services that privately are already being provided by pregnancy care centers and other, like, especially religiously affiliated organizations across the country, even without government intervention. With that said, I completely support, I think, more robust family policy that is providing, whether it's direct payments to women who are pregnant, especially if there's a marriage benefit. I think American Compass has a great plan on this. If you've looked it up, they have a great plan for how to, beef up the child tax credit and actually provide direct support to women who are pregnant, and actually continuing after pregnancy all the way up until the child is 18. And I think that those sorts of pro-family, pro-natal policies are really excellent. And I think you also see some benefit from this internationally as well, in countries that have these sorts of pro-natal, pro-family policies. So I'm certainly supportive of all that as well.
I think there's also initiatives done by different organizations, such as I think it's the Knights for Columbus, for example, that actually have women look at the ultrasound of their child very early on so that they can hear their baby's heartbeat. I remember I was 10 weeks pregnant, and I could still hear it was a very rapid heartbeat, but it's there. And it's quite, being a first time mother, it's really striking the age of which your child is a creature, is a human being. And I believe in, life begins at conception, but how powerful that can be for someone who perhaps needs that visual or that, that sensory experience to be able to hear that, that their child in the womb has a beating heart like they do. So are there any other kind of, maybe not necessarily policy oriented, but just cultural of life, things that organizations are doing that you found to be particularly helpful for, maybe opening women's eyes to the resources and alternatives that to abortion.
Yeah, I think you're exactly right. I mean, hearing that heartbeat on the monitor for the first time, when that heartbeat starts 18 days after conception, that's 3 weeks, right? So even before many women know that they're pregnant yet, that child already has a heartbeat. And of course, the pro-abortion left says that, well, it's not a heartbeat, it's just cardiac activity, right? Well, I won't hold my pulmonary respiration for them to be honest about that, right? Trying to make it sound all scientific when we all know it's a heartbeat. Yes, I think that absolutely there are resources out there to help educate. There's so much misinformation out there about the human development in the womb, and it's very it's because they're coming from a place, the people who are spreading this sort of misinformation about fetal development are coming from a place where they want to justify abortion. And so that's why they use terms like clumps of cells and, try and obfuscate about the fetal heartbeat and try and, say that the child can't feel pain and stuff like that. But I think that it's really important to be able to share those educational resources. Free ultrasounds is an excellent way of doing that. A lot of organizations, like you mentioned, the Knights of Columbus, many pregnancy care centers, will offer free ultrasounds. Save the Storks, I know, offers free ultrasounds in their, basically they'll bring a van with a wonderful, state-of-the-art ultrasound monitor, and they'll bring it right outside the abortion clinic and offer free ultrasounds. So I think that those sorts of resources are really important, and being able to distribute medically accurate information about human development in the womb is really important. Live Action is doing a great job of doing that, by the way, through their social media channels. For example, just influencing on Instagram, informing people about human development.
As an aside, there are some studies that I was reading when I was writing a piece about abortion recently that the rate of women deciding to not get abortions goes up in places where it is required that they look at a ultrasound of their baby before they choose, because it's unavoidable visually, right, that it is a human being. And I think that is very illustrative of the stakes, really, on the dividing line of the abortion debate, which is humanization versus dehumanization, right? One side requires dehumanizing the unborn child in the womb to make their case, and the other side has to humanize it to make their case. But I think that gets to one of the last sort of political questions I just wanted to ask you, Josh, which is I am very concerned that the Republican Party is not ready for a post-Roe America, that they haven't really figured out what their message is going to be, how they're going to sort of describe their position on abortion to voters, because now that abortion is potentially going to re-enter the political process for the first time in a half century, to a certain extent, both parties have been caught flat-footed. But I think if they aren't really ready to sort of go on the attack and have a viable sort of messaging apparatus, they could get caught by this sort of democratic backlash that sort of paints them as extremists or anti-woman, et cetera, et cetera. To me, the most obvious solution for messaging on this stuff is just to force the left to actually engage on the fundamental terms of whether or not this is a human child we're talking about, because that pretty clearly exposes the brutality of their position. But have you been talking to folks about potentially what sort of Republicans should be messaging on post-Roe? What are your thoughts about what the Republican Party message should look like on abortion after Roe is potentially overturned?
Yeah, I think Roe and Casey have given both sides reason to be lazy about how they approach the issue. On the pro-life side, as you mentioned, it's been easy for legislators to pass legislation that they know is going to be enjoined by a court on the grounds that it's unconstitutional under Casey. On the other side, I think that the pro-abortion side has gotten to be lazy in their messaging as well, because they can just say, well, it's a constitutional right. Roe and Casey guaranteed it. It's a liberty. It's part of my body, my choice. That's what the Supreme Court said. And so I think that both sides are going to have to figure out and really engage with the issue. And I think you're absolutely right that the pro-life side needs to continually bring it back to the humanity of every human being as a person. Every human being deserves to be protected by love and by law. And I think that's the kind of core message that has to get across after Dobbs.
Josh, before we wrap up, we want to ask you the question that we ask all of our guests, which is how you would define conservatism.
Conservatism is a collection of different beliefs rooted in tradition and history, I think I would say. I don't think it's ideological per se. It's kind of anti-ideological. But I think that conservatism is rooted in the best that's been thought and said in the Western tradition, and looking to the lessons of history, while also recognizing that history doesn't repeat itself, and that the only way out is through. So moving forward with the broad basis and a knowledge of history and tradition, while being able to apply that to the current situation that may not be exactly the same. So I think conservatism is an anti-ideological outlook that draws the best of what's been thought and said and has a great respect for tradition and history while applying it to new circumstances.
Well, thanks so much for joining us today, Josh. If people are interested in seeing more of your work or following you, where can they find you?
Well, they can find me on Twitter at Josh J. Craddock. You can also find my article, Protecting Prenatal Persons, in the Harvard Journal of Law and Public Policy. And you can also find articles I've written in National Review and the Public Discourse on related issues.
Great. Thanks again.
Thank you.
Thank you for listening to Conservative Conversations with ISI. If you've enjoyed this podcast, please feel free to head over to isi.org/resources to see all that we offer our members, including the Intercollegiate Review, select modern age articles, ISI books, and of course, this podcast. Thanks again for listening. Don't forget to rate and review, and we will see you next time on Conservative Conversations with ISI.